Hello and welcome to the Smart Contracts blog. This episode is about the most profound question in any contract that relates to upstream oil and gas, and that is, what is consequential loss exactly? Smart Contracts blog. The bright side of contracting in oil and gas. Special thanks to Hub Project for hosting the filming of the Smart Contracts blog. Located in the most desirable area in the Mexico City, Hub Project is an unparalleled platform for connection, creation, and innovation. Thanks a lot. It's very hard to imagine any contractual terms and conditions in upstream oil and gas for services, for supply, for drilling, for any associated services without consequential loss clause. The tradition is, and Macondo hasn't changed the tradition at all, that both parties to the contract waive or sometimes they indemnify each other for all or some of their consequential losses. Depending on the type of the contract, the parties will choose very simple, very short and concise consequential loss clause. Sometimes they go for really long and detailed clauses. So let's check it out. Schlumberger terms and conditions for purchase orders. Neither party shall be liable to the other for any punitive, indirect, or consequential damages sustained by the other party or its affiliate in connection with the performance of the agreement, including without limitation, business interruptions, loss of profits, loss of revenues, loss of use of assets, and loss of contracts. And some clauses tend to be very, very detailed. Let's take OMV form of contract for oilfield services. They suggest consequential loss, the definition of the consequential loss. Consequential loss means remote, indirect, consequential loss or damage, or special or punitive damages, loss of reserves, loss of revenue, profit, anticipated profit, use, or business opportunity, and losses, costs, and or expenses resulting from business interruption or deferral of production. It says here in bracket that consequential loss definition excludes any termination fees. And later, OMV form of contract gives quite a detailed clause with waiver, with full waiver by both parties, reciprocal waiver. And it says whether or not such consequential loss was foreseeable at the time when the contract was signed, in the time of entering into the contract or not. That's a very, very important addition. Repsol form of contract for provision of drilling rental tools, equipment, and services goes even further, and in the definition of the consequential losses, it says consequential loss means 1, 2, 3, and 4, whether direct or indirect losses related to these categories that they are listing here. And they go even further in the exclusion language, and lawyers call the mutual waiver an exclusion clause, and any exclusion of liability will be your exclusion clause. And in the exclusion clause, a Repsol contract goes even further and provides the full reciprocal indemnity from the contractor to the company group and from company to the contractor group. A very frequently used FIDIC silver book provides the following. Neither party shall be liable to the other party for loss of use of any works, loss of profit, loss of any contract, or for any indirect or consequential loss or damage which may be suffered by the party in connection with the contract. Back to the question, what is consequential loss? One of the main moving parts and the main identifying aspect or part of what is consequential loss and what is not to the parties of the contract is the wording of the actual clause. It is also obvious that governing law of the contract will have a profound impact on how that wording of the consequential loss clause will be interpreted, will be understood, and will be disputed by the parties. But do we really want to get to the dispute at the end of the day and allow the judge, whether it's in English law or whether it's in Russian law or the laws of the UAE, allow the judge to decide whether a certain loss is consequential or not. I would say in the upstream oil and gas contracts, it's critical that we don't go that far. And as contractual professionals and as lawyers in upstream oil and gas, we actually here onshore decide what is consequential loss for us and what is not, and include it into the precise wordings of the contract. If you want to learn more about fundamental nature of the governing law of the contract, join the online course that I will be launching on 13th of August 2021, where one of the video lessons is devoted to a very detailed description of what is governing law, what is dispute resolution, and how two of these aspects of the contract are identifying the life cycle, the interpretation, and the destiny of the contract. With the majority of upstream oil and gas contracts being governed by laws of England and Wales, I would like to pay close attention to English law and the development of legal proceedings in English law in relation to consequential losses cases. And in the next episode, I will discuss one case in particular, which is very impactful and had a very strong impact on how things developed in contract drafting, and should be known to all of you, those people who watch the Smart Contracts blog. So in the next episode, I will talk about the case where Transocean and Providence were disputing in court on how they understand the consequential losses definition in light of freedom of the contract and in light of the breach of contract that happened when the rig was not ready in time and up to the standard of the contract. So look up for the next episode and click leave your comment below and share this episode. Make sure that you leave the comment because I will attend all of them, and see you in the next episode. Thank you for attention.